Good. Okay, good afternoon, everyone. We're going to do our magistrate's docket this afternoon. I'm Rag Singhal. I'm the judge this afternoon. We've got Mr. Linder here for the state, Mr. Reedy for the defense. I'm going to start out of order, though, with Nikolai Soldan, because we have a Russian interpreter here.
He's approaching, Judge.
Great. Hi, Mr. Romero. How are you?
Good afternoon, Judge. How are you?
Doing well. Nice to see you.
Nice to see you, Judge. My understanding, this is a municipal ordinance, so the Public Defender's Office doesn't represent this gentleman.
Sure. Okay. So first thing is, just for the record, ma'am, do you swear or affirm to well and truly interpret from English to Russian, Russian to English to the best of your ability?
Yes, I do.
Okay. Mr. Soldan, you're accused of a municipal ordinance. It's basically just drinking alcohol in public. You're in jail. You're entitled to have a lawyer help you with this. Can you afford a lawyer?
Okay, Mr. Soldan, во-первых, вас обвиняют в том, что вы пили в публичном месте, в общественном месте. Положен адвокат. Вы можете нанять, у вас есть средства нанять адвоката?
Нет.
No, I don't have means to do that.
Okay. So I'm happy to appoint a lawyer for you. It's just this one count. There's a $100 bond, which means you can bond out for that amount of money. Otherwise, I hope that you'll be able to work this out quickly, and I do find probable cause. I wish you the best of luck.
Да, я с удовольствием для вас найму адвоката. У вас будет адвокат общественный. И также я даю залог в $100. То есть, заплатив $100, вы можете выйти из тюрьмы. И я надеюсь, что вы решите эту проблему. И я желаю вам удачи, всего хорошего, до свидания.
А можно я поеду домой и привезу деньги?
But can I go home and bring the money in?
You know, that's a good question. I can't let you do that, sir, but you can make a call to someone who can bring the money.
Вы знаете, это хороший вопрос, я не могу вам позволить сделать это, но вы можете позвонить кому-то, кто привезет вам деньги.
Я один живу, мне некому звонить.
I live
Три дня
alone.
назад дочка погибла, поэтому я напился, расстроился.
Okay. Well, I live alone. I have nobody to call. And 3 days ago, my daughter died. That's why, perished. That's why I was so upset and distraught.
Okay. Well, sir, I'm very sorry to hear that. What I think we should do is I'm going to set the bond at $100. Maybe we can bring you back on a second look docket later this week, and at that point, we'll have a lawyer here that can help you. Right now, the lawyers that are here are not the ones that are assigned to your case, okay?
Я вам приношу свои соболезнования, и я вам даю залог в $100, и через неделю мы вас приведем обратно в суд, когда у вас уже будет адвокат. Сейчас эти адвокаты, которые здесь сидят, они не являются адвокатами по вашему делу. Когда вы вернетесь в суд, вы уже будете с адвокатом, и тогда, я надеюсь, мы решим этот вопрос.
Thank you, Madam Interpreter.
Спасибо, переводчик. Всего хорошего, до свидания.
Okay. And then we're going to go to Renata Milner.
She's in North Broward.
North Broward.
Judge, we'd like to resolve this matter today if possible.
Hello.
Ms. Milner, good morning. Or good afternoon, actually. Good afternoon, I'm sorry.
It's not a good afternoon, sir.
It's fine, it's fine. You are here for some traffic charges. One is very old, from 2010.
Yes.
One's from 2018. There's a total bond set on your cases of $500. That means that you can go ahead and bond out. I'll ROR you on the 2010 case so that you can bond out for $500. Do you understand?
Judge, I don't think she's
Can
going
I-
to be able to
is
make
it
that bond. I
possible?
had spoken to Ms. Hold on, Renata. I'd
Yes,
spoken to
sir.
Mr. Lender, Judge, and I'm hoping that we can resolve this matter today.
Your Honor, the state's offer, if she wants to resolve both charges, would be withhold court costs on each count.
Ms. Milner, if you want to give up your right to a trial by jury, enter a plea of no contest, the agreement would be that you would not have a conviction on your record and you would have to pay court costs.
And how much is the court cost? Because I live off disability. I'm epileptic by the state, so I get my money through the state.
I don't know how much the court costs would be. Maybe the court would consider converting it to a civil lien.
I mean, I don't have a problem with that. Are you both are trying to keep an adjudication off for record? Is that
We are, Judge.
okay?
Frankly, Your Honor, because of the age of the first charge and just the nature
Sure.
of the second, that's why I made those offers.
Sure. I have no problem converting that to a civil lien in this particular case. Does Ms. Milner want to resolve both these cases?
Yes, she does, Your
Yes,
Honor.
sir.
Okay, ma'am, would you raise your right hand for me?
Oh, Jesus.
Okay. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? No, that's not going to work. So we're going to go ahead and pass your case, and the next one I'll call is Anne Marie Grant.
So that's it?
No, ma'am, you'll be handled at the end of the docket. Anne Marie Grant.
What does that mean?
What that means is that you need to answer yes or no, not and if you're too sleepy to take a plea, then we can do it tomorrow, ma'am. Anne Marie Grant.
Ms. Grant is here present, Judge, at Maine.
Okay. Okay, and Ms. Grant, you're here on a traffic capias. That's a warrant for a traffic charge from 2017. There's a $50 bond set for you. I do believe there's probable cause to hold you for that. Anything before we move on on that?
No, Judge, she informed me she's going to self-bond.
Okay, great. I wish you the best of luck, ma'am. Next one is Olga Ramsey.
On post.
She bonded, Judge.
Okay. Thank you. Next one is Crystal Ellerby.
On posted.
She bonded as well, Judge.
Thank you. Next one is Ella Brungard.
She's here present at Maine. Come on up, Ms. Brungard.
Hi, Ms. Brungard. You're before the court with two charges. One is resisting an officer without violence, and the other is petty theft. I do believe there's probable cause to hold you on these charges. I can set bond at $100 on the resisting an officer charge and $200 on the petty theft. And I do wish you the best of luck, and hopefully you'll be able to resolve these cases. Thank you, ma'am.
Judge, the only thing I'm going to be asking Your Honor is to consider leaving the standard bonds in place on, which is $100 on count one and no bond necessary on count two. My understanding is she already contacted her family. I don't know if her family's right now in the process of bonding her out. If the court were to change the bond, that might delay her being released. I believe she has minimal contact with the criminal justice system, so that's why I would ask you to consider just leaving the bonds in place.
You know, it's a good argument. It's a $85 theft from a cab driver, and I know how hard the cab driver probably works to provide for his or her family. I think $100 on count one and $200 on count two is fair. Thank you.
Yes, sir.
Okay, next one's Andrea Murray.
Medical reset, John.
Okay, med reset. Next one is Martha Garcia.
Ms. Garcia is here, Judge. My understanding is she has private counsel, Mr. Omar Lopez. Y solamente hablas español? And she's going to require a Spanish interpreter, Judge.
We have a Spanish interpreter on the way, and we're trying to reach our private attorney.
Your Honor, okay. I'm being advised her bond's been posted.
Okay, so several things. Mr. Romero?
Yes, Judge.
Could you help me out with just one issue? If you could tell this defendant that her bond has been posted.
Tu fianza ya fue pagada. Te van a liberar. I told her that her bonds have been posted and she'll be processed out to leave today.
Great. Thank you so much for doing that for me.
And I'm not going to call her.
Okay. The next case is Stephen Smith.
He's in North Broward.
North Broward. Okay. And Stephen Smith in North Broward, good morning, sir. You're before the court with one petty theft charge. There is probable cause to hold you on this. There's a $100 bond in place. Tell me what you want to do on this case. You are entitled to have a lawyer represent you. Any thoughts?
I spoke to the public defender earlier. I wasn't sure what the proceedings are on this.
Do you have a public defender there with you?
No, I spoke with him, Judge.
Okay.
I was going to ask the court to consider releasing Mr. Smith on his own recognizance. He's been a resident of South Florida for 35 years. He's been living at the same address, which is his condominium, since 1994. He recently graduated from FIU with a dual major, and he has no prior contact with the criminal justice system.
Okay, on Stephen Smith, in light of Mr. Reedy's argument, I will release him ROR. Okay, next case is Gary Johnson.
Gary Johnson. The judge calling you. Judge Mr. McClure.
Good afternoon, Judge. How are you?
Is he Maine?
How you feel?
I think so.
Hey, how are you? Mr. McLawrence, nice to see you.
Yes, Judge.
Gary Johnson's got two municipal ordinance allegations against him. One is trespass, one's disorderly intox. I do believe there's probable cause. There's a bond set at $25 on one case and zero on the other case. Mr. McLawrence, what would you like to do for him today?
Judge, he would like to resolve this matter if he could, Judge.
Sure.
I think he has a bus ticket, or he's heading up to Naples, is it?
Yes.
To take care of some rehabilitation matters, Judge.
Are you okay, Mr. McLawrence, with adjudication time served?
Yes, Judge.
Okay. Mr. Johnson, do you need any more time to talk to your lawyer about what's happening right now?
No, Judge.
Okay. Would you do me a favor and raise your right hand for me? Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, go ahead and put your hand down, sir. Your true name is Gary Dean Johnson?
Yes, sir.
And were you born on the 7th of June, 1963?
Yes, sir.
Okay, so listen, you've just got two municipal ordinance violations. One's a trespass, one's a disorderly intoxication. Got a great lawyer that's standing next to you. What he's been able to work out for you is that if you plead no contest today, I would just give you a time served. You would be convicted of the charges, but you'd be free and clear and you could go on your way. Is that what you want to do?
Yes, Your Honor.
Mr. Johnson, by doing that, do you understand you're giving up your very important constitutional rights? You will no longer have a trial. The state or the city won't have to bring in witnesses to prove the charges against you. Mr. McLawrence won't question those witnesses. Nothing will have to be proved against you beyond a reasonable doubt. You're giving up your right to appeal anything other than the illegality of the sentence here today. And these two charges can be used against you in the future. What that means is, for example, if you were to get a felony charge, you would get less than half a point total, but that would go on a score sheet and could give you a worse sentence on a future case. Do you understand all of that?
Yes, Judge.
Sir, do you have any questions for me whatsoever?
No, sir.
At this time, then, do you want to plead no contest on these two charges?
Yes, sir.
I do find that Mr. Gary Johnson's extremely polite. He's very well represented. He understands the nature and consequences of the plea, and I do sentence him on the trespass and the disorderly intoxication to adjudication, time served, concurrent. Mr. McLawrence, thank you very much for your work on that.
Thank you, Judge. Judge,
thank
I have one other case. It's on the second look docket, if I could just call it while I'm here.
Sure. Which case will that be?
Just go up here and outside. Judge, it's Van Star.
And Your Honor, I didn't have anything on the MO cases only because they're not in my system.
So we don't have any paperwork on it?
I can look on Odyssey to see what I can
All right. Okay. Mr. McLawrence, I do not have any paperwork on that case, but talk me through it a little bit and let's see if we can't come up with something here.
All right, Judge, I'll make it very simple. He's charged with a municipal ordinance battery. I spoke with the city about the matter. They've been unable to contact the alleged victim in the case. I set this on the second look docket in the hopes that they would have made contact, or they would have, if they didn't make contact, that they'd be willing to drop the case. But at this point, the city is not willing to drop the case, and they just want to have more time to make contact. So we're not going to be able to do anything with his case today is the bottom line. Okay. All right. Well, thank you for your efforts on that. And as soon as you need it heard, just let us know and we'll take care of it. He's being held on some other cases, Judge. So so the municipal ordinance, I was just hoping to resolve it today. But like I said, we're not able to do that today. Okay. Thank you very much, sir. Okay, thank you, Judge.
Well,
He's no bond on a different case?
He was out on pre-trial.
Okay.
But the only other thing I didn't know of Mr. McLaurin, I see we have someone on the felony second look, Your Honor, that apparently is also being held on an MO as well. I didn't know if that was one of Mr. McLaurin's cases.
Mr. Romero, is Mr. McLaurin still there?
He is, Judge. He's right here.
Oh, okay.
Dung Dang.
Mr. McLaurin, there's another defendant on the second look docket. The name is Dung Dang, D-A-N-G?
It's a Hollywood case, Your Honor, so it wouldn't be Mr. McLaurin's.
Oh, it's not, you know what, it's a Hollywood case, so no worries. We'll do it later. Thanks.
Maybe there's a lot of repairs.
Okay, next is Marvis Washington.
Well, that's not me.
here present at Maine.
Mr. Washington, good afternoon. You're before the court because of an active warrant for a driver's license issue. It's operating without a valid license. There's a bond that's set at $500. You do have a hearing before your judge next week, the 19th, which is a week from tomorrow. I do find there's probable cause on the charge. Okay?
Your Honor?
Yes.
And I don't know if Mr. Washington is inclined or if the court's inclined, but in my system, the ASA that's handling this case documented an offer on May 8th of this year of withholding court costs. So I would present that to Mr. Washington for instance.
Mr. Romero, Mr. Linder is extending the previous prosecutor's offer of withheld in court costs if Mr. Washington wants to resolve it at this time.
Let me ask him, Judge.
Sure.
Judge, in speaking with Mr. Washington, he wishes to accept the state's offer.
I'm sorry, he wants to accept it?
He wants to accept the state's offer, Judge.
Great, okay. And Mr. Washington, would you raise your right hand for me? Sir, do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead and put your hand down. Your true name is Marvis Washington?
Yes.
And you're born the 28th of August, 1992?
Yes.
Mr. Washington, you're before the court on a driver's license charge. It's operating without a valid driver's license. You are entitled to have a jury trial to handle this charge, and that's the kind of trial where you'd have a lawyer like Mr. Romero there to represent you. The state would always have to prove the charges beyond a reasonable doubt. They'd call in witnesses. Your lawyer would try to cross-examine them and would do everything he could to help you. But if you want to plead no contest and accept the state's offer of withheld and court costs, that means the following. You wouldn't have a conviction on your record, but you'd be giving up your very important trial rights. There would be no trial in the future. You couldn't come back in later and say, you know what, I should have had a trial. Is that what you want to do, plead no contest and take a withheld and court costs on this?
Yeah.
Okay. Have you thought about it, and have you had enough time to speak to Mr. Romero about it?
Yes.
Do you have any questions at all?
No.
Do you understand that this can be used against you in a couple ways? One is if you ever get in trouble in the future, this will be on your record. Two is that if you get 3 of these kind of charges in a 5-year period, the Department of Motor Vehicles might take your license for 5 years. Do you understand that?
Understood.
Okay. And knowing and understanding those things, you still want to go ahead and plead no contest?
Yes.
All right. I do find Mr. Marvis Washington is polite, alert, and intelligent. I find that he's been very well represented by Mr. Romero from the Law Office of the Public Defender, and that he understands fully the nature and consequences of the charge and the plea. I'm going to accept his no contest plea. I'm going to go ahead and sentence him in accordance with the state's offer of withheld and court costs. Sir, I do wish you the very best of luck. You do have 30 days within which to appeal any mistake you think I may have made. I'd appoint a lawyer for you if you couldn't afford one. Take care.
Take care.
Kevin Campfield?
I'm sorry, Judge, who did you call?
I'm sorry, Kevin Campfield.
Mr. Kevin Campfield is here. Come on up, sir. He's approaching, Judge.
Mr. Campfield, good afternoon. You're being held at this time for a DUI-related charge. It's 1 count of DUI and then a separate count of DUI with property damage. It's really all out of one incident, but they can't have 2 charges like this. The bond's $500 on the first count and $1,000 on the second count. You can go ahead and bond out and then attack these charges once you're out, and hopefully you can have a lawyer that'll help you with it. I wish you the best of luck, sir.
Thank you, sir. Good luck, sir.
Next one's Joshua Nelson.
Mr. Nelson is here present. He's approaching. Come on up, sir.
Mr. Nelson, good afternoon. You're here for a trespass charge. There's a bond of $25 on this. Do you think you can afford that?
No, I can't, sir.
Okay. Mr. Romero, anything you want to do on this case? I do find there's PC.
Judge, actually, Mr. Nelson, in speaking to him earlier today, he wishes to ask the court if you would consider resolving this case today for time served.
Sure. He's okay with adjudication time served?
Yes, Judge.
Okay. Mr. Nelson, is that what you want to do?
Yes, sir.
Okay. Would you raise your right hand for me? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, I do, Your Honor.
All right. Go ahead and put your hand on. Your true name is Joshua Nelson?
Joshua Joshua Cardine Nelson.
Okay. And sir, you're born the 15th of October, 1986?
Yes, sir.
So listen, you're accused of 1 count of trespass. You've got some options here. You could fight the charge, or you could go ahead and plead no contest. I'm being told that you want to go ahead and plead no contest. If you do that, what you're doing is you're giving up your very important trial rights. What that means is that there's nothing left that Mr. Romero could do for you in the future on this. You wouldn't have a trial. The state wouldn't have to prove things beyond a reasonable doubt. No witnesses to cross-examine. This would be on your record. What I'd be inclined to do would be to give you adjudication time served. And what that means is that you would be released later today if this is all that's holding you. Do you understand?
Yes, I do understand.
Mr. Linder?
The only other thing I would ask is a condition of the sentence is that he not return to Parrott's Landing.
Okay. So, sir, I'm not going to put you on any probation or anything like that, but I am going to order that you not return to the place of this trespass, and specifically that's Parrott's Landing, 7900 Hampton Boulevard, North Lauderdale. Do you understand?
Yes.
Okay. Now, I also want you to know that this can be used against you in the future. If you were to get in trouble, it'll be on your record. It'll come with just 0.2 of 1 point, but it could affect you in the future. Do you understand?
Yeah.
Okay. Do you have any questions at all of me or Mr. Romero?
No.
All right. Then at this point, Mr. Nelson, do you want to plead no contest?
Yeah, I'll plead no contest.
All right. I do find Mr. Joshua Nelson is very polite, alert, intelligent. I find he understands the nature of the charge, consequences of the plea. It's been very well represented by Mr. Hector Romero from the Law Office of the Public Defender. I find that the plea is being entered into knowingly, voluntarily, and intelligently. I'm going to go ahead then and accept the plea. I'm going to find the defendant guilty, adjudicate him, give him time served. Sir, you do have 30 days within which to appeal any mistake you think I may have made. And if you needed to take an appeal, I'd appoint a lawyer for you, but I do wish you the very best of luck. Thank you. I'm sorry? I'm giving him time served, adjudication time served. I'm not going to assess court costs on it. Okay, Keith Fernandez?
Bond posted.
Okay, great. Next one is Joseph's, what?
I was just going to let you know the Spanish interpreter is present also.
Oh, we may need you later, but Mr. Romero actually took care of the one where we needed you before because the individual bonded out. But can you sit tight for a few minutes? Okay, thanks. Joseph Sunday?
Mr. Sunday is here present, Judge in Maine, and he did decline the services of public defender.
Okay. All right. And Mr. Sunday, you're before the court on a misdemeanor DUI charge. I do find probable cause to hold you. There's a bond set at $500. I do wish you the best of luck, sir. Thank you.
Thank you.
Next one is William Guess.
Mr. Guest is here present, Judge in Maine.
Hi, Mr. Guess. You're here on a misdemeanor capias. That means a warrant. That warrant is in the amount of $500, and I do find there's probable cause to hold you on that. Just to give you a little bit of information, looks like it came out of the South Courthouse, the Hollywood Courthouse. So I can't tell who your judge will be, but you'll have to go down there to answer to this charge, and I hope you can work it out.
And Your Honor,
Judge, and speaking of Mr. Guest, he wishes to ask the court or if the state has an offer in order to resolve his case.
Any offer, Mr. Linder?
yes, Your Honor, the offer that was documented by the assigned prosecutor on July 2nd of this year would be withholding court costs, no return to the McDonald's at 1310 South Federal Highway in Dania Beach.
Withholding court costs with no return to the specific McDonald's where this occurred.
Let me relay it to him,
Sure.
Judge. He wishes to accept the state's offer, Judge.
Mr. Guest, would you please raise your right hand for me? Sir, do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do, sir.
All right, go ahead and put your hand down. Your true name is William Guest?
Yes, sir.
And, sir, you're born the 25th of November, 1953?
Yes, sir.
Okay. Sir, you're accused of a trespass charge. It's at a McDonald's in Dania Beach. You have every right to go ahead and fight this charge. If you wanted to fight the charge and you couldn't afford a lawyer, I'd appoint one for you. At such a trial, what would happen is the state would always have the burden of proof. They'd have to bring in witnesses and prove the charge beyond a reasonable doubt. Your lawyer would help you by attacking the evidence. He'd cross-examine the witnesses. He'd confront them. He'd call in any witnesses you and he'd think might help you. He'd do all the things that you know lawyers do to help their clients. He's not going to do those things anymore because you're telling me you want to plead no contest. You want to accept the state's offer of withheld adjudication. That means no conviction. You would be assessed court costs, and you also could not return to the place where this trespass occurred, which is the McDonald's in Dania Beach. Do you understand?
True. Yes, sir.
Do you have any questions at all?
No, sir.
Do you understand that by taking this plea, the case ends, nothing else to do on it other than pay your court costs, but it could affect you in the future, it'll be on your record, and could be used against you at that time. Do you understand that?
I do, Judge.
Okay. At this time, you want to plead no contest?
Yes, sir.
Mr. Guest, I'm going to accept your plea. I do find that you're very polite, alert, intelligent. I find that you have been very well represented, that you understand the nature of the charge and the plea, and that the plea is being entered into knowingly, voluntarily, and intelligently by you. I'm going to go ahead and find you guilty, but withhold adjudication, assess court costs, and order no return to the McDonald's in Dania Beach. You have 30 days within which to appeal any mistake you think I may have made. I'd appoint a lawyer for you if you couldn't afford one, but I do wish you the very best of luck, sir.
Thank you, Judge.
Thank you. Thank you. How about Luis Morphy?
Mr. Morphy is here present, Judge. He's going to require a Spanish interpreter.
Okay, and we're...
He declined the services of public defender, Judge.
Okay, thank you, Mr. Romero. Madam Interpreter, would you raise your right hand? Do you swear to well and truly interpret from English to Spanish, Spanish to English to the best of your ability?
I do. Pleasure to see you, sir.
Nice to see you. Mr. Morphy, you're before the court accused of one count of burglary of a structure.
Señor Murphy, usted está aquí enfrente de la corte acusado de un cargo de robo de negocio.
There is also a petty theft charge, and I find probable cause on both charges.
También tiene una acusación de robo de grado menor. La señoría decide que hay motivo fundado para los dos cargos.
I'm going to set bond at $2,500 on count 1, ROR on count 2, and I do wish you the best of luck, sir.
La fianza queda designada en $2,500 para el primer cargo y queda en libertad bajo su propia palabra en el segundo cargo. Le deseamos mucha suerte, señor.
Gracias.
Thank you, sir. Thank you, ma'am.
Gracias, señor. My pleasure. Have a nice afternoon.
You too. Thanks. Next case is Nelson Mendez.
Judge, maybe the Spanish interpreter should make an announcement to make sure there's...
Oh, that's a great idea. Ms. Sands, if you would...
Mr. Mendez, come on up.
Mr. Romero, before we do that, the Spanish interpreter is going to make an announcement.
Yes, Judge.
Si alguien más necesita los servicios de la intérprete, por favor avisar a la persona que está a cargo.
Alguien habla solamente español. Solamente español. No one else here at Maine is going to require a Spanish interpreter, Judge.
Great. Thank you so much, Mr. Romero.
Yeah, we might at the other jail.
¿Alguien más en los otros centros?
Conti is good.
Conti's good. How about North Broward? Anyone need a Spanish interpreter over there? Okay. All right. Okay, I think we're good. Thank you so much, man. Back then to Nelson Mendez.
And Mr. Mendez is here at Maine, Judge, and he declined the service of public defender as well.
Okay, thank you, Mr. Romero. Mr. Mendez, you're being held on 4 counts of possession of tools for forgery or counterfeiting, 1 count of passing a counterfeit bill, check, draft, or note. I do find there's probable cause for each of those 5 charges. I'm going to set bond at $1,000 on each of those charges for a total bond of $5,000, and I do wish you the best of luck, sir. Thank you very much. Next one is Kenneth Phillips.
Mr. Phillips is the person, Judge.
Mr. Phillips, good afternoon. You're before the court on 2 matters. One is a driving while license suspended habitual charge. On that, there's a bond of $750. I do find there's probable cause. On the second one, it's what's called a writ of arrest, and there's a $268 amount there. What that means is if you pay that amount, that issue will basically go away. Do you have any questions, sir? Okay, all right. Thank you guys very much.
Thanks, Judge Phillips. I'll call your sister right after court, okay, sir?
Anthony McPhee?
Mr. McPhee is here approaching, Judge. He declined the services of public defender.
Okay, thank you, Mr. Romero. Mr. McPhee, you're being held on one count of driving while license suspended, third or subsequent offense, and also an expired motor vehicle registration. The expired registration, you don't have to post any money to get out on that. The driving while license suspended, I'm gonna set bond at $750, finding probable cause. Wish you the best of luck, sir.
Yeah, so that's what I had to do today. Just had to post bond today.
You can. If you're not being held on anything else, then if you post bond of $750, then you'll be released, sir. Thank you. Albert Bernasette?
Albert Bernasette, bonded, Judge.
Okay, thank you very much. Yorick Scott? Mr. Scott, good afternoon. You're before the court on a few different charges. I just want to read them to you. You have one count of felony possession of cannabis, one count of possession of cocaine, one count of tampering with or fabricating physical evidence, one count of smuggling a controlled substance against the provisions of Florida Statute 893.02, one count of driving while license suspended as a habitual offender, and then one count of failing to register a motor vehicle. I do find that there's probable cause to hold you on these charges. I am going to set bond as follows.
Your Honor?
Yes.
If I may, on count 4, I believe the officer put the wrong subsection in because it's listed as prison where it should be detention.
Detention?
Okay. And that would make it, I believe, a third-degree felony with a standard bond of $1,000.
Of $1,000 instead of $3,500.
Yes.
It's funny, I was going to reduce that bond anyway, but, okay. Sir, on counts 1 through 4, I'm going to set bond at $1,000 each count. On count 5 at $750. On count 6, ROR. So your total bond, sir, is $4,750. I do wish you the best of luck. Thank you,
Judge,
sir.
the only question I'm going to have is, unfortunately, I haven't had an opportunity to review the PC affidavit.
Sure.
In reference to count 2, the possession of cocaine, is it a residue case or not?
If you look at the bottom of page 2 on the PC, it says update, and it references a small plastic bag of white powder.
Yes, thank you, Judge.
You bet. Thank you. Next one is Tyrese Grant Campbell.
And, Your Honor, if I could be heard before the court.
Mr. Grant Campbell is approaching, Judge.
Sure.
Thank you.
All right.
Your Honor, I'm going to be requesting.
Let me do this. Let me read the charges, and then we'll go right to you. So, on Tyrese Grant Campbell, sir, here's the charges: 2 counts of aggravated assault, as written on this report. It says with a deadly weapon without intent to kill, but reading the PC, it's actually a firearm. Count 3, burglary, dwelling, structure, or conveyance while armed. Counts 4 through 8 are juvenile holds.
And, Your Honor, I'm going to ask that this matter be reset for tomorrow morning and the court defer ruling pursuant to Rule 3.133A1. I spoke with Deputy Drazen, and I've asked him to provide a supplement with some more information. Unfortunately, he works the night shift, so he won't be able to provide that to me before tomorrow morning.
So we would bring Mr. Grant Campbell back tomorrow on the 8:30 docket?
I would ask for tomorrow morning, Your Honor, to get it back as quickly as possible. And also just noting for the record that he really suffers no prejudice at this time, considering the juvenile holds, he wouldn't be eligible for release before then anyways.
Mr. Romero, any legal objection to me rolling this over to tomorrow morning? That's 7/12 at 8:30.
I believe the state can ask, and for purposes of if they don't feel they have sufficient information to establish probable cause, I believe the law allows them to make that request and you to honor it, Judge. So if it's based on that, I have no legal objection.
Sure. Just if it's 3.133A1, my guess is it's not probable cause as much as pretrial detention, so.
No, basically what it states, Your Honor, is that the probable cause at a non-adversarial probable cause determination, it has to be made within 48 hours. So if we're reset for tomorrow morning, he has to have his first appearance today where you advise him of the charges.
Sure.
The PC determination doesn't have to be made until 48 hours, so resetting it for tomorrow morning would still be within that window.
Okay. All right, so Mr. Grant Campbell, you're gonna be back. It won't be with me, it'll be with a different judge, but it'll be tomorrow morning, on the 8:30 docket. If you have, any family members that you're dealing with on this case, you should just let them know that, okay? So that they know where you are and when you're gonna be in court. All right? Thank you, sir. Next one is Torrance Hayes.
He's approaching, Judge.
Mr. Hayes, good afternoon. You've got two charges, possession of MDMA and resisting an officer without violence. Those are new charges. You also have a series of, well, not really a series, but two violation cases. So there's really not much I can do for you here today. I'm going to set bond finding probable cause at $1,000 on count 1, ROR on count 2, but you're being held no bond on the violation matters. You'll be in front of Judge Porth a week from today. That's the 18th at 8:30 in the morning, okay? I wish you the best of luck, sir.
Good luck, sir.
Next one's Kendall Smith.
Mr. Kendall Smith is approaching, Judge. He declined the service as public defender.
Mr. Smith, good afternoon. You're here really with one criminal charge, which is driving while license suspended, third or subsequent offense. There is probable cause to hold you on that. I'm going to set bond at $750 on that, so you can bond out. Count 2 is a headlight charge, so there's no bond required on that one. Okay. I do wish you the best of luck, sir. Sir.
You on him?
Yes.
Okay.
Okay. Next one is Peter McDonald.
Mr. McDonald, come on up, please.
Okay, Mr. McDonald, good afternoon. You got a series of charges. I'm just going to read them out to you. You have one count of misdemeanor driving while license suspended, one count of possession of drug paraphernalia, one count of distribution of methamphetamines, one count of possession with intent to sell or deliver methamphetamines, one count of possession of alprazolam, one count of grand theft auto, and one count of dealing in stolen property. I do find that there's probable cause to hold you on these charges. I am going to set bond as follows. Counts 1 and 2, which are the misdemeanors, $100 each. Count 3, $2,500. Count 4, $2,500. Counts 5, 6, and 7, $1,000 each count. So your total bond is $8,200. I do wish you the best of luck, sir. Mark Jacks.
Mr. Mark Jacks, come on up, please. He is approaching, Judge.
Mr. Jacks, good afternoon. You're before the court on a couple issues. You have a possession of cocaine case here in Broward. I do find there's probable cause to hold you on that charge, and I'm setting bond at $1,000. But more significantly, you've got some out-of-county holds, and those bonds have been set by your judge out of county. There are 5 separate holds. They may all be out of the same case, and those bonds are $5,000, $5,000, $15,000, $15,000, and $5,000. So your out-of-county bonds total $45,000. The bond for the possession of cocaine here is $1,000 for a total of $46,000. I do wish you the best of luck, sir. Okay, going back to North Broward for Renata Milner. Renata Milner.
Coming up, Your Honor.
Okay, Ms. Milner, let's talk about your situation here. You have two traffic warrants, one from 2010, one from 2018. I'm told that the state is offering you a way to resolve these charges. Mr. Reedy, what was the plea that this?
It was a withholding court cost.
And court costs. You can resolve both of these for withheld and court costs, or you can bond out for a total of $500. It's your choice. What would you like to do, ma'am?
So the first one, what does that mean?
Okay, so the first one, what you could do is if you pled no contest, and that would be your choice, then what the state is offering is withheld adjudication, which means no conviction, and court costs on each of the two charges. You had indicated that because of some illnesses, you didn't feel you'd be able to pay the court costs, so your lawyer, Mr. Reedy, asked if I would go ahead and convert those court costs to a civil lien, and I'm happy to do that for you. But
yes,
none of us here want to force you to resolve a case with a plea, because ultimately this can really affect you. Both of these charges would be on your record. If you got a future charge, it could be worse because of these two charges. Sometimes the Driver's License Bureau can do things and take your license away. So you have to know all these things, and we just really need to know what you would like to do. You can go ahead and bond out. You can think about it and come back later in the week. You can go ahead and plead no contest today, whatever you want to do.
Whatever sends me home today.
Well, if you enter a plea
no contest, sure.
If you enter a plea of no contest, this case will be over. I don't show anything else holding you, so you would be released.
Okay, let's do that then.
Okay, so here's the thing. I don't want you to plead just so you can go home today. You could also attempt to post a bond today. I just want to make sure, I'm happy to go ahead and accept your plea, but I just want to make sure you understand the consequences. You can't come in later and say, you know what? I only pled to get out of jail and now I want a trial. We can't go backwards at that point. Do you understand?
I'm trying to, yes, sir.
Okay, so when you say you're trying to, what can I explain to you better? Because I want to make sure you understand everything.
What I really just don't understand is you say the bond out and then something with civil. So that means that it won't be there anymore, or
okay.
I'm trying to understand. I'm confused. I haven't had my meds, so I'm trying.
So we've got a couple issues, Miss Milner. I think that everyone here is working to try to get you home, okay? And but one of the problems is I can't really accept a plea if you're confused. And particularly if the confusion is based on the fact that there are medications that you need. It's just dangerous for both of us if we do that. And so there are a couple things that I can do. Do you have medications in the jail with you?
No, sir.
Okay. Mr. Reedy?
I asked them when the officer arrested me. I explained to him my situation. I let him know that I had Tegretol and Dilantin in the car, gabapentin. I had all those medications in the car. And I asked him if it was okay for me to do that. And the officer told me I couldn't have those things. And he put me in the back seat of the car while I was in the midst of a seizure. I'm okay with pleading no contents because I have children to go home to, but that's basically it.
Okay, guys, what kind of criminal history, if any, does she have? Sure.
And, Your Honor, to answer your question,
If the court's not comfortable taking a plea from Ms. Milner at this time,
I'm comfortable sending her home, but I'm not comfortable taking a plea, so that's why,
Right.
but I need to make sure that she doesn't have,
well, the only problem, as Mr. Linder pointed out to me, is that when the 2010, was it, the 2010 case was a 30-day SAP, so there's actually a
was-
SAP.
order.
When Judge Pollock was her judge at that time in drug court, and when she issued the no bond capias, she put a 30-day SAP hold on it. And also, I don't think it's necessarily an issue. I think just to be safe, Mr. Reedy would have to, if the court's inclined to release her on that case, he would just have to prepare an order stating that any hold for a SAP would be deleted. Your Honor, if the court's inclined, I spoke to Mr. Reedy, I see nothing significant here. My thought was possibly release to, on both cases, release to pretrial, considering that there is a failure to appear from a 2018 case.
Ms. Milner, are you still on, at that Northwest 18th Court address?
4820, yes,
Sure.
sir.
Okay. So listen, I don't think it's right for me to take a plea from you today. I want you to get stabilized on your medications. I'm gonna go ahead and send you home. I'm gonna ROR you to pretrial release. They're just gonna have to take some information regarding your address and all of that. But listen to me. You're gonna get a court notice, or maybe 2 court notices at that address, and you can't miss court. You have to come to court and take care of these cases, because otherwise you're gonna get a 3rd case, and that, each time it gets worse, okay? So
Yes, sir.
it'll take a while to process you out. You're gonna get home tonight, and just take care of yourself, and then when you get, actually, she has these statuses, are they set still, if I ROR?
They might change.
Yeah, I'm not sure if those stay in place as long as she's in custody. Madam Clerk, do you know if those stay in place whether she's in custody or not? The status hearings that are set on the docket, are those deleted if she's released from custody? Okay. Yeah, I believe they'll send out new notices.
Okay, so they're not deleted, they stay.
Okay.
Okay. I
thought that's what
I thought they're deleted.
I thought they were, and the new notices go out.
Okay. It's 6 days away. Okay. All right, so Ms. Milner, you're gonna get a court notice in the mail, okay? You have to make that court date, okay? All right?
Okay.
And,
Yes.
and I do wish you the best of luck, and take care of yourself, all right?
Yes.
Okay. Sure, so,
Thank
all right,
you.
so North Broward pretrial is gonna call and interview her right now and take the information, okay? Thanks so much.
Okay, good luck, Ms.
Thank
Milner.
you.
What do you guys have left? Just second looks?
Second looks
Have
and some motions to
second look,
release.
Judge, and we have 30-day ROR motion. Yeah, I can ask, Judge.
Yes.
I'm being asked by one of the deputies here if we could call a gentleman out of turn.
Sure.
His name is, I'm looking at his name on the document, his name is Ryan Robinson.
Ryan Robinson, sure.
And he's approaching right now. Come on up, Mr. Robinson. Here's
Okay.
Mr. Robinson, Judge.
All right, and so I'm showing that probable cause was found for criminal mischief, resisting without, and trespass. He's been in, I guess, 5 days now, and what are you guys looking to do?
Well,
Judge, speaking of Mr. Robinson, he's, well, obviously he's still in custody, so I don't think no one can afford to post his bond. He does say he has a place to stay with his friend who lives locally. So, Your Honor, we'd be asking you to consider releasing him on pretrial release.
Your Honor, my concern about that is he was arrested March 20th of this year on burglary of a conveyance and attempted burglary of a conveyance. He was released at pretrial. He was then picked up for violating his pretrial, and he received a 120-day jail sentence and was released May 21st. Ryan Robinson.
Unfortunately, Mr. Robinson was aware previously he was placed on pretrial. He violated pretrial, but I know one of the issues that led to him violating pretrial, from what he's advising me, was unfortunately he was homeless at the time. That presented a host of problems. At this time, he actually has a place to reside with a friend that lives in Oakland Park. So he's advised me that now those problems won't come to light, so he'll have no problem abiding by pretrial. Correct.
What's the bond that's currently set?
$700.
Well, a couple things I can tell you, Mr. Robinson. First of all, Mr. Romero always does a great job, but I think you got pretty lucky that this bond was set at $700. I'm reading in here that the victim is 89 years old, and that really bothers me a lot. So I'm happy to talk about what we can do in terms of release. Because if you can't afford $700, you wouldn't be able to afford $10,000 or what I think the bond should be. That having been said, you have a valid Broward County address, this place that Mr. Romero is talking about?
Yes.
What's the address?
208 Lake Point Drive, Oakland Park, Florida, apartment 102.
All right, so you guys need to take a look. The PC's got a very different address. It's got 201, apartment 101. So, well, I could release him there on an electronic monitor.
That's fine. Judge, that's fine. Are you working right now or no? No. Judge, the only thing I would ask, on this, the monitor, there's, I believe, a $5 per day cost associated with it. Would you consider waiving the cost of the monitor?
I don't have a problem with that. I think he does need to find work, and these are just allegations, but he's got to work toward restitution if he wants to try to resolve this. So.
Absolutely.
Okay, thanks.
Thank you, Judge.
Okay, the next one I have. Oh, so listen, on all bonds, I should have said that when I came in. No victim contact. And in fact, in this case,
do you want me to have Mr. Robinson come back, Judge? So you
yes, please.
Mr. Robinson, come on. He's approaching, Judge.
Okay. Mr. Robinson, as a condition of your bond, you're to have no contact with the victim on this case. No contact means no contact in person, over the internet, even making a comment on a blog. Just absolutely not allowed. Not by you, not by your roommate, not by any family members. If there is any such contact, then you'll be placed in custody until your trial date, okay?
Okay.
Thank you.
Good luck. Judge, the next gentleman we have here is Mr. James Roberts.
Yes.
He's also on your second look docket. Come on up, Mr. Roberts. Mr. Roberts is here. He's been since July 7th on a $300 bond. It's a resisting without violence, a trespass, and obstruction of highway. Okay. Judge, unfortunately, Mr. Roberts is indigent, but he's asking me to ask the court if you would consider resolving his case today, Judge.
Okay. Mr. Linder, what do you think?
The state's offer to be adjudication, time served, no return on all counts.
He wishes to accept the state's offer, Judge.
Okay. All right, Mr. Roberts, would you please raise your right hand for me? Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Your true name is James Roberts?
Yes, sir.
And you're born 10/19/61?
Yes, sir.
So, Mr. Roberts, you're before the court accused of a couple charges here. The charges are resisting an officer without violence, trespass after warning, and that traffic charge, Mr. Romero, is that a misdemeanor, or is that, what is that, like a traffic ticket?
It's a second-degree misdemeanor.
It is a second-degree misdemeanor, so obstructing traffic, I guess, really is what it is.
Yes.
You have the absolute right, sir, to have a jury trial to handle these charges. A jury trial is a proceeding where your lawyer and the lawyer for the state would pick 6 members of the community who would hear all the evidence in your case. The state would have the burden of proving the charges beyond a reasonable doubt. Your lawyer would help you by attacking the evidence. He's not going to do any of those things anymore because you're telling me you want to plead no contest. You want to accept the state's offer, which is that you'd be convicted of these 3 charges, you'd receive an adjudication, but your entire sentence would be time served. Is that what you want to do?
Yes, sir.
So you understand, Mr. Roberts, that by doing this, you're giving up some very important rights, like the right to go to trial, to confront and cross-examine witnesses, to call witnesses of your own. You've got the right to testify or not testify, whatever you choose. You will be giving up any appellate rights you have unless what I do today is illegal. You will have these 3 convictions on your record, which could be used against you in the future. Do you have any questions whatsoever about what's happening today?
No, sir.
Do you need any more time to speak to Mr. Romero?
No, sir.
At this time, Mr. Roberts, do you wish to plead no contest?
Yes, sir.
Okay, I do find Mr. James Roberts appears today to be polite, alert, intelligent. I find that he understands the nature of the charges, consequences of the plea. I find that he's been very well represented by an excellent criminal defense lawyer with whom he appears to be satisfied, who's worked this case out very well for his client. I find that the plea is being entered into freely and voluntarily with a knowing, intelligent waiver of Mr. James Roberts' rights. On the 3 charges before the court, I'll find Mr. Roberts guilty. I'll adjudicate him, sentence him to time served. Mr. Roberts, you do have 30 days within which to appeal any mistake you think I may have made. I'd appoint a lawyer for you if you couldn't afford one. Mr. Romero did a great job for you. I wish you the best of luck.
Thanks so much.
Thank you.
Judge, the next gentleman is Mr. Antonio Brown. Come on up, sir. Judge, Mr. Antonio Brown is on your 40-day docket on case number 18-6808-CF10A.
Okay, so this is Antonio Brown. He's before the court. There are 2 charges, burglary of a conveyance and petty theft. The docket seems to reflect that even the petty theft is filed, or not filed, but is charged as a 3rd-degree felony. The date of arrest is June 8th, 2018, and we're here today, July 11th, so it's the 33rd day?
And, Your Honor, an information has been filed. It was filed today. The burglary was filed as presented. The felony theft was down-filed to a petty theft, so the jail will update that bond as soon as they receive the paperwork. Just to advise the court, Mr. Brown's also being held no bond on pursuant to a court order on a separate felony matter.
Okay, thank you. So, Mr. Brown, I don't know if you heard all of that, but basically what's happened is on this case, which is at the 33rd day, the state's filed an information today. One of your felonies went down to a misdemeanor. The other one's as charged. I do wish you the best of luck, sir.
Good luck, sir. Judge, the last gentleman we have here at Maine is Mr. Valsen Schneider, and his case number is 18-6819-CF10A. Same thing on the 40-day docket.
Very similar situation, also a June 8th, 2018 arrest. 1 count, 3rd-degree felony, theft, 1 misdemeanor, false ID given to a Leo. Mr. Linder, anything you can tell me on this one?
Your Honor, the information was filed today, both counts as presented.
Okay, so Mr. Valsen, an information was filed today on your case, 1 3rd-degree felony, 1 1st-degree misdemeanor, and I do wish you the best of luck in resolving these matters.
Judge,
Yes, sir.
I believe one of them cases have the false information that the judge had told me that they didn't file this. This was dropped. And I was hoping that we could resolve this problem. It's a petty theft, third offense. I was hoping that I've been in for 33 days. I was hoping that we could resolve this today.
I think you very well could resolve this case. I don't know much about your criminal history. Now that the case is filed, it'll go to your division judge hopefully rather quickly, and he can resolve it. Do you have a date or anything? That you
No, but since it was filed today, I imagine an arraignment day will be scheduled forthwith. But just, Your Honor, so what I think Mr. Valston is talking about when he says he was advised the false ID was dismissed, when he was arrested pursuant to bond issues, I'm sure you're familiar, on the booking sheet, it said no charge, meaning no bonds attached.
Right.
It's very easy to read that as there's no charge.
You know, in any case, I don't think that that's really the biggest worry that he has. Do you know who his division judge is?
I can check that.
Or what the letter is?
He is, I believe it's before Judge Fine.
Okay. So, Mr. Valson, you're going to go before Judge Fine. He's pretty quick with setting his arraignment dates. My guess is you'll see him next week, and at that point, if you are interested in resolving the case, then I'm sure that they'll help you. Okay? Thank you.
Thank you.
Thank you, Judge. We're done here, I think.
Okay, Mr. Romero, have a great rest of the week. Thank you so much for your hard work.
Thank you, Judge.
These other individuals are North Broward? Let's see. Sure. Hi, who do we have left at North Broward? I can't hear him.
Hit the button, deputy.
Oh, there you go. No worries, no worries. Okay. I thought it was me. Yeah.
WOOLD, Wood, Lubin. On the third day.
Sure. Okay.
Come on.
Pages 2 and 3 of the 30-day docket, Wold Lubin. And just looking at it, it looks like this is May 13th and May 23rd, 2018. It looks like May 13th, though, was when he came in, and that the May 23rd date is probably ad charges or something.
That's correct, Judge.
Okay.
Going through them one at a time, I can advise the court on case number 5680 was filed. On case number 185836 CF10A, we merged that charge into the 5680, so the motion can be granted on case number 5836. And on case number 186506 CF10A, we have not filed an information at this time, so he's entitled to an ROR on those charges.
Okay. And that's on 6506?
Yes, sir.
All right. Mr. Reedy, anything you wanted to add?
No, Judge. Mr. Linder advised me, and I advised Mr. Lubin, that apparently he has a no-bond hold on the 1856-80 case because Judge Siegel revoked his bond. Was that what it was, Mr. Linder?
Yes, his bond, yes, that's correct.
Okay, so at this time, Mr. Reedy, do you want me to grant the ROR motion on 18006506?
Well, Mr. Lubin, if the judge RORs you on that count, you're not going to get any credit for time served. Would you rather the court impose a dollar bond so you keep getting credit for time served on that case? Or do you want to be ROR'd? All right, I'd ask you to grant the motion, Judge.
Okay. And Mr. Lubin, you understood what Mr. Reedy just told you, right?
No.
Okay. Not sure.
What charge I'm getting RR for?
Okay. So you have a number of different charges. On the burglary dwelling and the grand theft, you're entitled to an ROR, but you're not going to be going home. You're going to still be sitting in custody on a no bond on other charges. Now, If you stay in custody and a year from now you work these cases out, you don't get credit for that year on that burglary, dwelling, and grand theft case if they file the charges. So that's why Mr. Reedy was asking you, do you want to be ROR'd or do you just want to leave things the way they are?
ROR.
Okay, so I'll grant the motion for ROR on 18006506.
But
On 18005836, there's really no case left anymore since that merged, but technically I'll grant the motion on that one. And then he's being held no bond on 18005680.
Your Honor, is that charge been filed?
Yes, sir.
I don't got no court date.
You'll get your court date soon, I would think. Do you know, you don't have a court date yet, Mr. Linder, right?
No, Your Honor, it was filed, I believe the charges were filed today as well.
Right, you should get your court date very soon since the charges were just filed today. I wish you the best of luck, sir.
All right, thank you.
Thank you.
Your Honor, next we have Dr. Reno Cheryl on the second look docket.
Sure. Thank you. Cheryl Yacarino.
Yes, sir. Good morning. Good afternoon.
Yeah, good afternoon. So this is a second look docket case for a petty theft, but it's filed as a third-degree felony, or it's not filed?
She was arrested for a felony theft. The filing decision has not yet been made.
Oh, this is just filed on?
Yes.
Or just arrested on July 7th?
Yes, sir.
Okay, got it. Let me take a look.
All right. Next.
And, Your Honor, when the court's ready, I have some information upon reviewing this PC affidavit.
Sure. Go ahead.
Certainly, I think with the court, I wasn't here for the first appearance, but reviewing the end of the report where it mentions the two theft cases.
Right.
That 182323 MM48 case is still pending. So certainly, obviously it's something the court could take into consideration that she's allegedly getting arrested for a new theft while on the theft. It can't be a consideration for a charge of felony theft. And ultimately, if charges are filed, unless there's other thefts out there, I don't imagine it would be filed as a felony theft, at least not based on these two case numbers.
So, listen, and I appreciate that. The 99 case was already a felony. We don't know really what that
Yeah, I just want the court to be aware, because I didn't realize at first, and obviously, I don't know if it was brought to the judge's attention at the first appearance when the judge found PC. I guess that was over the weekend.
Sure. So, Ms. Yacarino, I don't know that I can really help you today because the state's still going to need to look at this charge and figure out whether it's a misdemeanor or a felony. If it's a misdemeanor, I think you won't have any problem at all getting it worked out. But I do need to give the state an opportunity to look at your criminal history and make that decision.
Can I say something, sir?
Sure. Just keep in mind, though, that you don't have your lawyer standing next to you, and, everything you say is going to be recorded and can be used against you, and a lot of times people say things that aren't in their best interest, so just be careful.
What I'm going to say is I haven't been arrested since, 2000. I haven't been in any trouble.
The other theft was at NTA, so...
I haven't been in any trouble since 2000.
What about your other 2018 case?
That's pending, sir. I'm going to trial on that.
Okay.
And Your Honor, I don't believe this was filed as a 30-day, I think this was set up pursuant to administrative order for a bond review, and that's why I was advising the court that.
What's her bond?
$750 because she was arrested on a felony. That's why I wanted the court to know.
Got it.
And she can't make that, Judge.
Ma'am, you're still at the Roosevelt Street address?
Yes, sir.
Okay. How long you been there?
Well, I'm not going to lie to you, sir. I just did. I went to prison in 2006 to 2017.
Okay.
She lives with her daughter.
Drug trafficking.
Sure, but then you've been at that Roosevelt Street address since your release?
Yes, sir.
Okay.
Which
And,
was December 1st, 2016.
okay,
She lives with her daughter, Judge.
all right.
I know. I was going to ask the court to consider pretrial release for Ms. Yassarino.
And Your Honor, in light of the fact that it looks like, from what I can tell, this could very well be a misdemeanor and the dollar amount involved, if they verify residence, I don't have an objection to pretrial.
Okay. She does know her address.
Sure. You guys want it? You guys want it? All right. All right, ma'am. Pretrial release is going to ask you a few questions once we move on to the next person. Yeah, I'm going to place her on pretrial. And then we're going to try to get you home. And then, you know, you need to make sure you don't miss any court dates, okay?
Oh, no, yes,
Okay.
no, sir, I know that.
Okay, thank you, ma'am.
All right, thank you.
Good luck, Cheryl.
Thank you.
Yes, sir. Collier, Reagan.
Your Honor, I didn't provide any paperwork. The reason being, you might remember we had him yesterday.
There's Ronald Wilson Reagan and Nancy
Yes.
Wilson.
Your Honor, he appeared before Judge Tobin Singer yesterday morning on a new battery here in first appearance. He was actually
Not by Ronald Wilson Reagan and Nancy Wilson.
He was supposed to be in front of Judge Lerner Wren on another case.
Okay.
He refused. I talked to Judge Lerner Wren's GA. They reset him for tomorrow in that case, and I believe Judge Tobin Singer had this case to follow. So I would just ask that the court take no action and let him go in front of Judge Lerner Wren.
And that'll be tomorrow?
Yeah, it's
Okay.
scheduled. That's what her GA told me.
Do you know what time?
I can check.
Mr. Reagan, how are you doing today?
Good, Your Honor.
Good. So listen, here's what we're going to do. We want to try to help resolve these cases that you have. I'm going to send you to Judge Lerner Wren tomorrow.
Okay.
Tomorrow, she works very hard to help people, and I think that she may be able to help you. And she'll at least look at everything you have and see if she can come up with a plan for you. Okay? All right. You okay?
Yes.
Okay.
And
all right. So
to answer your question,
I
Judge.
already know what you're doing, Supreme Court, Congress, and legislature. I'm regular calling.
Her MI docket starts at 9 a.m.
okay. So it'll be tomorrow morning. That's the 12th at 9 a.m. You'll be in front of her, and I wish you the best of luck, sir.
They don't have it. I have it.
Okay. Got it. Thank you, sir. As long as you have it.
Engdahl, Christopher, Your Honor.
What's that? Wrong way. Sorry. All right. And you said Christopher Engdahl?
Yes, sir. Yes,
Okay.
sir.
All right, so Christopher Engdahl is on page 5 of this docket, and it's a hearing on a defense motion for ROR. Mr. Reedy, you're handling this one?
Yeah, yes, I am, Judge.
Okay, and I got a few different probable cause reports on this, but
Your Honor, I presented those to Judge Siegel yesterday. We ended up resetting it to today. The reason I presented all that was the top report should be the battery Leo that he's before the court on today for a second look. But he's had numerous recent incidents in Broward as well. And it's one thing for me to tell you what he was charged with, and it's another thing to see what the allegations are. And that's why you have that packet there.
okay. All right, Mr. Reedy, what do you think?
Judge, we had Mr. Engdahl here yesterday with the hopes of contacting his sister. I left her my cell phone number. I've spoken to his sister in the past as well. I think the issue we had yesterday is whether or not he was going to be able to live with her and if she was going to be able to come get him. She indicated in the message that she sent to me that she would not be able to come and get him. I've had a lot of dealings with Mr. Engel, Judge, as the court can review with those probable cause affidavits. He indicates to me he's in need of some serious medical attention, which I don't know he's going to be able to get if he remains at the jail. He has indicated to me that he could live with his sister, even though she can't come get him. I would ask the court to consider releasing him. He's not going to be able to come up with any kind of monetary bond. That's based both on his age and his medical condition.
So, talk to me about something. She said she couldn't come get him.
Right.
He says he could live with her. Did she say he could live with her?
She did not address that issue in the email that she left, in the message that she left for me.
Well,
Your Honor, and Your Honor, frankly, I was not present when this was discussed, I guess, the end of last week about releasing him to his sister and GPS as an alternative. Frankly, I would have been opposed to that even as an alternative.
Okay.
Also, to let the court know, on one of the criminal missions previously, he was released at pretrial. He was given that opportunity. He quickly violated his pretrial by committing another criminal mischief. I understand Mr. Reedy's representing what Mr. Engel is telling him, but
sure.
As far as medical conditions, you can see right here, he's alleged to have kicked out a police car window.
Okay. Mr. Engdahl, it seemed like you wanted to say something. I just want to caution you, though. Mr. Reedy's over here. He's not standing next to you, and so he can't be, he can't handle things quite the way that he normally would. A lot of times people say things, and it's not in their best interest. Certainly, I'll give you an opportunity now to tell me what you want me to hear, but I just need to caution you to be careful, because anything you say can be used against you. Do you understand that?
I understand that.
Okay. And Mr. Reedy, if you need to stop him at any time, you hit some mute button over there or whatever you have.
I will. I'll stop him.
Okay. All right. Go ahead, sir.
Okay. I'm an amputee of all my toes. And in my property, I have an order to go to hospital to get diagnosed whether to amputate my leg. They want to give me IV antibiotics. All my doctors are in Broward County. I've been a Broward County resident for 55 years. I have vouchers to stay at a shelter in Hollywood off of Scott Street. I went up to the task force up in Fort Lauderdale and got stopped at a gas station. My cell phone was stolen and my bicycle, and I was beat up by 7 guys in a gas station when I went to the task force for the homeless. But I got the vouchers anyway after waiting 4.5 hours up there. But I am familiar with the bus system, the train system. I'm going to get back to my sister to stay, but meanwhile, I have to change all my doctors. Oh, I got 4 doctors that are in Broward County. I kept them that way because I lived in Davie. I've been living in Broward for, like I said, 55 years. I have no problem with pretrial release. I went there before twice, and I just happened to get a situation that I got arrested. It wasn't intended. And the one on the police officer thing, they took me to the hospital after the police took me to the hospital, and there was I had no drugs or no alcohol in my system. I have seizures sometimes. Supposed to see a doctor about getting my brain checked out because I was hit by a car. My back was broken. So if I can handle these things, I have enough money to from a government check to get a residence if I need to within a week.
Okay.
So I still have it for my doctors. And I will go to retrial release as requested. I know where it is, and I went there every time.
All right, so a couple things. At this point, we don't have any word from your sister that she would welcome you to live there. You've got a pretty compelling story. The problem is that I've got a police report with some allegations in it that, if what you're telling me is true, not sure why you wouldn't have just gone and taken care of your medical things instead of what these allegations are.
I was going
So-
to that next day, and the reason why they came for somebody
Okay,
else.
so
and
here you
that's
go,
why
here you go,
support.
sir.
Don't
Sir.
discuss the facts of the case.
Yeah,
Mr.
sir, remember how I'm using the word allegations, but everything you say is an admission, so, you need to be careful with that. So, at this point, though, I don't think that there's much I can do, Mr. Reedy, but if you get any information from his sister that is consistent with, her being okay with him living there, then at least a judge could look at an electronic monitor and placing him there.
I will continue to make efforts to contact her, Judge. I have, as I said, spoken to her in the past. I know she's very concerned about her brother. I don't know, but I can't say that she would agree to have him live with her. And the impression I got from Mr. Ingall is that that's not where he intends to go
Right.
anyway. She does not live in the Tri-County area. She lives up north Florida.
GPS wouldn't be an option.
Okay. All right, so it's denied for today, but let's see where we end up on it. So, thanks, guys.
Thank you, Judge. I'll call your sister again. If I hear anything, Christopher, I'll set you down for a hearing, okay?
All right.
That's it for North Broward, Your Honor. Thank you.
Okay, thank you so much. I really appreciate your help.
Thank you.
And we're over at Conti now.
Yes. How you doing, Judge?
How are you, sir? And what's your name?
Jerome Vaughn.
All right, everyone, this is Jerome Vaughn on page 4 of our ROR docket. And Mr. Vaughn has been in since the 7th of June, so 34 days. And Mr. Linder, what can you tell me?
Your Honor, the state has not filed an information at this time. He's entitled to an ROR in his charge.
And Mr. Reedy, nothing you wanted to say, right?
Judge, I have one thing to say.
Hold on one second. Right now you're winning, so don't say anything. All right. So, I'm showing just count 1, possession of cocaine. What do you show?
Your Honor, the motion was filed on on this felony offense. He has a separate misdemeanor case where a court ordered him to be held on a $1,000 bond.
Okay, that misdemeanor case, was it an arrest the same day that wasn't filed, or?
No, that was he was out on pretrial and a revocation order was signed, setting his bond at $1,000.
Right now, the only thing holding Mr. Vaughn in custody is a $1,000 bond on disorderly intoxication.
Because I'm gonna ROR him on this possession of cocaine. But,
I would like to resolve the other charge, Your Honor. Please.
you guys have a police report or something that I could look at?
I can get a report
Sure,
for you, Judge.
sure. And then, Mr. Linder, you need you to look at it to see whether it's something that you're amenable to resolving too.
Yes.
All right, Mr. Vaughn, just hang in there for a couple minutes so we can figure out if we can do something for you.
Thank you, sir.
Thank you. Thank you. Thank you. Did you get a chance to look at it?
I got it on my computer.
Okay, okay. Okay, so on this case, Mr. Reedy, did you see the PC?
I'm reading it right now.
Sure. So the PC has some things which are concerning, but ultimately the charge is disorderly intox. So, you know, as it refers to victims,
You know, and Your Honor, I was going to address that.
Okay.
I understand that's the language that the officer used. Just for record purposes, because I am prepared to make an offer to Mr. Vaughn.
Okay.
He was charged with disorderly intoxication, and on the information, there is no listed victim as per the statute doesn't require it. Your Honor, considering Judge Levinson signed the order on the bond on this case June 8th, so he's been in custody June 8th. Considering the amount of time he's been on this misdemeanor, my offer being adjudication time served.
Is that what you want to do, Mr. Vaughn? The
Yes,
court
sir.
accepts
Yes, sir.
the offer, adjudication time served?
Yes, sir. Yes, I do.
Mr. Vaughn, would you please raise your right hand for me? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
All right, go ahead and put your hand on your true name is Jerome Vaughn.
Yes, sir.
And you were born on the 24th of April, 1990?
Yes, sir.
So, Mr. Vaughn, you're accused of one count of disorderly intoxication. That's a misdemeanor, and you're entitled to have a jury trial to handle that. And at that trial, what would happen is the state would have to prove the charges beyond a reasonable doubt. And the way they would do that is they would call in witnesses, and then the witnesses would be asked questions, and the state would have to prove things beyond a reasonable doubt. Your lawyer would attack the witnesses' testimony by cross-examining them, confronting them. Your lawyer would also call in any witnesses that you felt could help you. You would have the choice of testifying or not testifying. Whatever you chose wouldn't be held against you. Your lawyer would file motions, make objections, do all the things lawyers do to help their clients. But none of that's going to be done anymore if you go ahead and plead no contest. Instead, what's going to happen is you would receive an adjudication or a conviction, and you've been in 34 days, you would receive a sentence of 34 days time served. Do you understand all of that?
Yes, sir.
Now,
I served my purpose.
Now listen to me. There's every possibility that if you went to trial on the case, you would lose and you could get a worse sentence. But there's also a possibility you could go to trial on the case and win, and then you wouldn't have the adjudication on your record. You understand that by pleading no contest, you're giving up those possibilities. You're locking in this deal, and you're saying, Judge, I just want time served, and I want to be done with this matter. Is that true?
Yes, sir, that is true.
Okay. You understand it can be used against you in the future. It'll be on your record. If you get in trouble, people can say, oh, look, he had a disorderly intoxication before, and that's just something that you would have to live with from here on out. Do you understand that?
Yes, sir, I do understand.
Do you have any questions for me, or more importantly, for Mr. Reedy over there?
No, thank you, Mr. Reedy, and no, I do not have any questions. Okay. Thank you, sir.
At this time, then, are you going ahead and pleading no contest?
Yes, sir, I am.
Or I do find that Mr. Jerome Vaughn appears in court today to be very polite, alert, and intelligent. I find that he understands the nature of the charge, the consequences of the plea, that he's been very well represented by an excellent criminal defense lawyer who, as always, has done an excellent job for his client. I find that the plea is being entered into freely and voluntarily with a knowing, intelligent waiver of Mr. Jerome Vaughn's rights. Any questions for me, sir?
Thank you so much, Judge. No, thank you.
On Jerome Vaughn, I'm going to find Mr. Vaughn guilty of the disorderly intoxication. I'm going to adjudicate him, sentence him to time served, which I show is 34 days. I do want to tell you that if you think I made a mistake today, you have 30 days within which to appeal, and I would appoint a lawyer for you, but I wish you the best of luck, sir.
Thank you, sir.
Thank you. Okay. Sir, good afternoon. What's your name?
Markendi Mombranch.
Okay. Do you know me, Mr. Mombranch?
No, I don't.
Okay.
And I would like to see if I can resolve this case, if that's possible.
Markendi Mombranch. Just looking at the charge, it doesn't look like it's going to be possible, sir. But let me tell you what I'm showing. I'm showing one count of dealing in stolen property. It's a second-degree felony. It's set today for a motion for ROR. Looks like you were arrested originally on July 7th. Mr. Reedy, are you involved in this one?
Your Honor,
I am now.
And Your Honor, just let the court know for whatever reason they're all called motions for RORs, but this is a second look. It's not for a motion for release.
Okay, but as far as a second look goes, if it's dealing in stolen property, I mean, what can I do?
You can
It's up to
address
you.
the issues of Mr. Montbranch's pretrial release, Judge.
It does.
Okay.
So the
That's
court's-
really why he's on the
Okay.
docket.
And so the court's aware, pursuant to administrative order, this offense does qualify for review.
Oh, it does?
Yes, it
Okay,
does.
all right, that was my question. I thought it was one of those ones that was on the list that I couldn't look at. All right, so talk to me, Mr. Reedy. What are you looking for? What's the bond right now?
3,500.
Okay.
Judge, obviously, Mr. Montbranch has not been able to make that bond. I don't believe there's anything else holding him other than this case. Do you have a place to stay, Mr. Montbranch?
No, sir. I'm homeless right now.
Where would you go if you were released?
I'll go to a first step. That's a sober living. That was my whole plan from being released right now.
How long have you lived here in South Florida?
23 years, sir.
And do you have any relatives or friends or family here?
Yes, I do.
Who do you have?
My brother, my mom, you know.
Who's your, is your brother's name Mackenzie by chance?
No.
Is there anybody I can call to come to get you out on any kind of a bond?
No. Nobody will pay. I don't have anybody that will pay the bond. Would it be possible if I get RR'd?
Judge, I'd ask the court to consider pretrial release for Mr. Montbranch if he's unable to post a monetary bond in the case. It would seem that that's the only way he's going to get out of jail.
You don't happen to have an evaluation from First Step Sober House that says they're willing to take him, right?
No, sir.
Just so the court's aware, at the time of this arrest, Mr. Montbranch was out in an ROR in possession of cocaine. That case is set in drug court before Judge Tobin Singer.
Okay. Well, here's my thought. How about if I do an order giving First Step access to him at the jail to evaluate him? And if they're comfortable with him staying there, then maybe we could release him on a monitor to First Step Sober House, which I think would also satisfy Judge Tobin Singer.
And, Your Honor, if I could just advise Mr. Montbranch, because just so he's aware, he is scheduled for arraignment before Judge Tobin Singer on his open case August 1st at 8 a.m. Court date notice was mailed, but based on his representations, I don't think he's gonna end up receiving that if he's out of custody.
Sure.
So at least now he's aware of that hearing.
Okay.
You might want to write that down, Mr. Montbranch.
August when?
Yeah, so just think of it this way, 8-1 at 8. 8-1 at 8.
8-1 at 8, okay.
Okay, and then we're gonna try to get First Step over to see you hopefully later this week. And then if that works for them, then I think that we can try to get you over there.
All right.
Okay? All right, sir.
Thank you.
Thank you. Hi, sir. What's your name?
Hi, William Hannigan.
And this is William Hannigan, page 6 of our docket.
This is second look.
And it's second look docket. Also at 7-7 arrest, third degree drug possession felony. What do you guys want me to consider?
Well, it's Mr. Hannigan's birthday. Happy birthday, Mr. Hannigan.
Thank you.
7-Eleven's typically a lucky day.
Judge, he's not able to bond out. You have a place to go, Mr. Hannigan?
I'm actually homeless right now.
Where would you go if you were released?
I have a friend's house that I stay with at Fort Lauderdale.
Do you know the address?
I don't.
Do you, know do you have a phone number?
I don't. But if I could be released into Bark.
How long have you lived here in South Florida?
10 years now.
Do you have friends or family here? Anybody who can come up with a bond for you?
No, sir.
Mr. Reedy, does Bark have beds readily available? I mean, if I hate to
don't-
say released into Bark and they don't have a bed for 6 weeks or something. I just don't know, because I'm not in that division anymore.
Yeah, I don't know, Judge. My understanding is that they, let's say, I wouldn't be willing to say that they do. It's not like you just show up at the door and walk in.
Right.
Arrangements would have to be made. I don't know his criminal history. Does he have a bad criminal history?
I'd have to run a check to see if he has anything outside of Broward, but as far as Broward goes, he had a street solicitation last year.
Could put him on pretrial release, Judge, even without a valid address. He'd still be under the obligation to report to pretrial release within 24 hours of his release from the jail, and it'd be his responsibility to make all of his future court dates.
What would we do for
my
that?
concern is
Would we
that
put him in
many-
Broward Outreach or something?
I can do that.
It would be incumbent upon him to find somewhere, but, you know, a few defendants. Right, we had a gentleman who was also,
The thing is, Judge, one of the things that we deal with in here every afternoon, basically, is that specifically drug charges are not filed within the 30-day time period.
Right,
Because the lab is, I don't know what the problem with the lab is, but, there's a pretty decent chance Mr. Hannigan's going to come back here in a couple of weeks. The charge will not be filed. He'll be ROR'd with no conditions. Basically, no restraints on him, no supervision by the court. He'll be left to his own devices. At least if you release him to pretrial, he'll have an obligation to respond there, check in with pretrial release, and keep in touch with them as to any upcoming court dates that he needs to attend. And in the meantime, he can get situated into some type of a drug facility.
But, Your Honor, my concern is essentially those conditions are also a setup for failure. This case is assigned to Judge Calra. I have no objection if the public defender is appointed to this case. If the court were to order him, pretrial release to Bark, if it is, I hope it wouldn't be as long as 6 weeks, but certainly if the public defender's office looks into it and finds out that's how long it is, then certainly they'd have every opportunity to file a motion for further review before Judge Calra.
If I might add something too.
Hold on.
As the PD is aware, in essence, what will then happen is we're going to remove his bond, and then he'll be just sitting in essence.
That is the other danger of that.
And I understand that we say, well, he can't post bond anyway, but I just want to make that clear that he will be sitting without bond.
But couldn't it be pending verification to Bark? As that would be the place he would be going, and once they verify that there is a bed open, then...
If we're going to do pending verification at all,
No, I'm listening.
I would say don't put Bart, because if, let's say, Bart can't see him and we send him to James Love or First and somewhere else, if you put Bart,
That's true.
finding him to Bart.
Right.
Then we have empty beds somewhere else.
Sure.
And the court, then the PD now will have to set a motion before the judge to have that. I just feel like if you're going to do pending verification, then it ought not say to Bart. It ought to say to him. Caveat that we know that we want him to go somewhere.
But what would it say, pending verification to a residential drug program?
Actually, I would prepare a short order, a regular pretrial supervision order, and it would just say pending verification. And if the public defender comes up with somewhere that they believe that he can go, then at that time, we would verify him, and he would go to that particular place. We spoke with, just to throw a name out there, Raymond Paglia of James Club, and he is to be transported by BSO custody to 425. The defendant must be released to Bart, and then we find out, second chance.
All right, so Mr. Reedy, it's really up to you and your client in terms of how to do this. I would like him to get treatment pending this filing decision based on what he's said and what you've said.
I think Mr. Hennigan wanted to add something.
Sure, sir?
Also, yeah, I just started working too, and I'm afraid that if I'm in here too much longer, I won't be able to keep the job.
Where are you working?
R&B construction.
An argument could be made that if Mr. Hannigan continues to use heroin, that a construction job might not be, there much success with that.
That's an allegation at this point. But I understand what you're saying.
But the allegations were probable cause that are before the court at this time.
Of course.
Sir, did you contact a halfway house, some kind of residential treatment? Have you spoken with someone since you've been in custody? Because I know that there are a lot of units over there in the county, and I'm well aware that defendants share information. So did you talk to somewhere, and maybe when one of those people came in, you were able to meet with someone already? Or did you not?
I haven't been able to yet.
So you had a desire to do that? Because I heard you say yet.
I've been wanting to, yeah.
I'm scared to ask. What can you do?
All right, so if we do pretrial release pending verification to drug treatment, and then he gets released, but within a certain number of days is not in a residential drug treatment, then
I don't want to sound negative, but God forbid the next time he gets arrested, there would be a warrant lingering out there for him somewhere.
Right.
That is one of my concerns about him being quote unquote set up.
All right, so I guess, sir, it's really up to you. If you're in residential drug treatment, likely you're going to lose that job anyway. So are you asking me to release you so you can keep your job or so you can get residential drug treatment?
I would like to get the treatment. I think that'd probably be the best thing.
Okay. All right.
Yeah, at least it'd give me a little bit of time. I could always explain to the job, what's going on. And
So I guess, Mr. Reedy, what you're asking me to do is modify the conditions of release. He's got a $1,000 bond right now, and what you're asking me to do is ROR him to pretrial with a special condition that he, within 72 hours of his release, enter residential drug treatment. Wait, so you're not, is this what you're asking for? I just want.
Yes, it is, Judge, and I appreciate what pretrial release is saying, and they have a very valid point. Mr. Hannigan, you're going to have to get into a program in the next 3 days. Do you think you can do that?
I understand.
Are you sure you can do that?
Yes.
In fairness, I believe he wants to do that, but there's no way he knows if he can do it at this point in time because there's no way he knows if there are beds available.
Right. And if he can't get in, then he's going to have a warrant out for him, or I can just warehouse him in the jail. I mean,
and the problem with the warrant is then it's not a willing violation. If there are no beds available, then that really wouldn't be a willful violation of pretrial if he's attempting.
Wait. So you guys are suggesting that there's not a bed available in the world that he could get into within 72 hours?
I don't know.
Absolutely, there's a bed.
I'm not suggesting that. I just know that from being in here, there are times when we think, for example, they can go to, ABC recovery, but they don't meet the requirements for ABC recovery. We think that they may be able to go to somewhere else, and there's a wait list. They can't get in until 10 days. Those are some of the hurdles, for want of a better word.
You have absolutely nowhere to stay, Mr. Hennigan?
I'm just with a friend right now, but I don't have an address or anything.
Well, if you went to your friend's house, you'd at least be able to stay there, right?
He doesn't even have an address, Mr. Reed.
But I don't have an address to give you. That's the problem with that.
But you know where it is, right?
Yeah.
So it's not a situation, from what he's telling us, Judge, that he'd be like on the streets. He'd have a base of operations, if you will.
No. The only reason I'm even releasing him is for him to get into the residential drug treatment. I mean, it's an allegation. It's a possession of heroin charge. He's telling me that he's got a problem. I mean, the other thing is I could just order him into SAP. And then he could get the treatment in custody and then finish that and be done with things. That's another alternative.
You familiar with the SAP program, Mr. Hannigan?
I'm not.
It's a substance abuse program in the Broward County Jail. In fact, I think it's in Conte.
It is in Conte.
They offer, pretty much the same type of services as a lot of drug rehabilitation centers on the outside, but you'd stay in jail. Would you be interested in that?
I would really rather have the opportunity to get out so I could speak to my boss and tell him what's going on.
Guys, what we'll do is let's let him speak with his boss by making a phone call to his boss, and then we'll bring him back after he's done that. I can put it on the docket for Friday or whenever you guys want.
That's fine, Judge.
Not sure why he's been in there 5 days and he hasn't called his boss.
I don't have any of my phone numbers.
How long have you been working at this place?
I just started last week.
Okay. All right, guys, I really want to give everyone the time that they deserve, but I think we're all kidding ourselves. If he started at a construction company last week, today is the 11th, so that would take us to the 4th. We know he didn't start on the 4th. That would take us to the 5th, and then on the 7th, he's arrested for possession of heroin. So, sir, basically, you had 2 days on the job, and then, I'm sorry?
It was like, I started like 4 days before I was arrested.
Okay, you're kind of making my point for me. You started 4 days before you were arrested. There was a holiday in between, and now, as far as your boss knows, you haven't shown up for 5 days. My guess is that job's not still out there. So I think we have to just really use our court time in a way where when Mr. Hannigan can present us with a viable plan, I'm happy to help him. But right now, there's just nothing there. So,
Mr. Hannigan, see what you can do about lining up a drug program between now and Friday afternoon.
Now on Friday?
Yeah, I'm going to bring it back on. I'm going to ask the court to reset your case for Friday.
Okay.
So we'll go to 7.
So when you come back on Friday, have some ideas for us.
I'm going to make a call to him.
7:13.
A pretrial release is going to call you, Mr. Hannigan. Listen very carefully to what they say.
Okay.
Okay?
All right. I wish you the best of luck, sir.
Right, good luck.
I'm just
Thank you.
And happy
kind of
birthday.
concerned about a few things, so that's all. Thanks.
So we're resetting him for Friday.
For Friday. Yeah, I think he's under a lot of pressure because it's his birthday too, and that's not a great day to release somebody, I just hope, he seems like a good guy, so hopefully it'll work out. Okay. Sir, good afternoon. What's your name?
Don Dan.
Sure.
Hi,
Page 7. Hi, how are you? Page 7 of the docket here, and
he's
similar
got a-
situation. What do you think, Mr. Reedy?
He's got a municipal ordinance case as well that's on the other docket.
Okay.
And he's got a $1,100 bond. And Mr. Dang, are you able to make that bond?
No, sir. I don't have a job right now, but I need your help. I need a household or something to stay and looking for a job.
You have a place to go?
He said House
Yeah.
of Hope. How'd you come up with House of Hope?
I asked some people.
Okay.
So they say that they can help you stay and look for a job for you, and you go to work and coming back. So the first time I need it.
So can we get these guys evaluated or something, just because so that I can.
Every place is different. Some places go in and interview them in the jail. Other places want to know if they have insurance. That's their
Right.
first question. So have you spoken to anybody from House of Hope, Mr. Dang?
Yeah, actually somebody come household before and in the jail, and they told you asking you guys for the households, and you guys can help me there for 90 days or something. To by the time I stay there, I looking for job and work, and in the forum, if you can. I don't know, like which up to you. If you can help me, I can help.
Okay. So you guys help me out a little bit on this. I mean, I want to get these guys help. I want to get them into treatment as opposed to the jail, but I can't just kind of arbitrarily say release to House of Hope or release to this place or release to that place, because, you know, I mean, I was in the criminal division for years, and they have to evaluate the people and tell me that they have a bed available. So.
And that's one of the issues. I was just talking with that defendant, for example, and I explained to him that different ones have different criteria.
Sure.
There are some that will not take you if you have insurance. They will say if you have any sort of insurance, they won't take you.
Well, like Mr. Hannigan, the one before, he'd be perfect for a First Step Sober House because he could go there, he could work, he could pay the $160 a week or whatever the amount is.
I actually told him that that was one of the places he should.
Okay, I think that would work for him. Sure. Okay. Well, what about Mr. Dang, though? I mean.
Call House of Hope right now, Judge. Yeah, he says he spoke to somebody at House of Hope. Do you know who you spoke to, Mr. Dang? The name of the person?
Yes, sir.
What is it? Who did you speak to at House of Hope?
Can you say again?
Yes, who did you speak to at House of Hope?
Some people in jail. Some people where I stay with now, yeah.
Okay, so other people that are in jail or someone from House of Hope that came to the jail?
Some people in jail,
Okay.
They come in the House of Hope before.
So it's inmates.
Yeah, inmates. Yeah, the inmates. Mm-hmm. Yeah.
All right, so.
So they say work over there. If I don't have a place to stay, so come there. So they're looking for a job for me too, or I can work by myself.
All right, so I just need these guys to have something in place so I can do what I have to do. No, he spoke to inmates. He's never spoken to someone from House of Hope.
Yeah,
he spoke to inmates. He just spoke to other inmates who said, hey, House of Hope, it might be good for you. Sure.
Yeah, I started looking through.
Yeah. Sir, have you been to House of Hope before?
Never.
I
never.
Have you ever had drug treatment help before?
I've been to treatment before.
Where did you go?
In Daytona.
In Daytona. Nothing in Broward?
Nothing in Broward. Yeah, in Daytona. 28 days. Yeah. But I never been to the House of Hope before.
I was working on a file this Saturday, and when I contacted the facility, though she hadn't spoken to the
Right.
Yeah, I checked some prior cases to see if there was ever, but there was nothing.
So, I mean, right now, I don't think there's anything I can do for him either. I just need something to be put in place, and then I can order him there. If House of Hope, if First Step, if any of these places are willing to take him, I'm happy to send them.
You want to reset him for Friday as well, Judge?
I
can't get through to anybody at House of Hope right now.
Okay. 7:13. All right.
I'll make some phone calls between.
Okay. All right, sir, we're gonna bring you back Friday and see if we can get something in place for you, and if you're able to reach House of Hope, that would be great.
Thank you, sir.
Thank you.
Thank you. So I'll see you on Friday.
It won't be me, but you'll see someone.
You'll see me.
Yeah, you'll see Mr. Reedy.
Okay. Thank you, sir.
Thank you.
All right.
Yeah. I'll see you later. You have a good day.
You too, sir. I hate saying you too. I mean, he's in jail, but you know. Okay, who's the next one?
I think we have, this is Kevin O'Kane, Your Honor, I believe. Your Honor, I didn't print out a report. The reason being, He's being held on local charges on a criminal mischief, so there's issues with him making an offer on that.
Okay.
The other issue is, as pretrial correctly stated, he's got a parole hold out of, I believe, New York. So there's another issue with resolving this matter.
Okay.
It's Florida.
I thought it was. I apologize. Then it's a parole hold out of Florida, but it's still the same issue.
All right, so Mr. O'Kane, you have, you understand what was just said? Apparently you have this criminal mischief charge here. You've been in about 15 days, but separately you have a parole hold. And so as a result, I guess, Mr. Reedy, I don't know if you've worked on this. It does say PD on it, but.
I have not personally, Judge.
Okay, so it's sounding to me like it's not in his best interest to resolve the criminal mischief until people can figure out what effect that'll have on the parole hold?
I think that would be correct.
Okay. You understand that, sir?
Yes, sir. That was my intention anyways, is to fight the misdemeanor. Because that's the reason why I violated.
Got it. Okay. Why do we keep bringing some of these people back then?
This probably came back because the criminal mischief by itself qualifies.
Qualifies, okay. All right, sir. Sorry to have brought you over. I think seems like you understand what you have to do to try to help yourself. Okay?
Yes,
I wish you the best of luck.
Good luck, man.
Thank you.
Are we all set?
How you doing yet?
Okay, great. Thanks so much for all your help.
All right, bye-bye.
I think the last two cases are at Paul Ryan.
Paul Ryan?
Yeah.
Last but not least is Paul Ryan.
Good afternoon, sir.
Hey, how are you?
Good, sir.
Okay. Thank you. Okay. And what's your name, ma'am?
Jocelyn Rivera?
Okay, Jocelyn Rivera is on page 6 of the second look docket.
Oh, yes, Your Honor.
Yes.
I was advised that Ms. Rivera had her bond revoked on another case this morning by Judge Usan. So she's being held no bond on a possession and care of fentanyl case.
Okay.
That would appear to be the case, Your Honor, so there's
All right.
probably not a lot to be done on the $1,000 bond that she has on the cocaine charge.
Let me ask you guys this. SAP is SAP for female inmates too? Okay. Mr. Reedy, in light of what you guys have told me and what the 2 charges are that she has, I don't know why she's turned around. Okay. Do you want me to order her into SAP?
Yeah, it's up to her.
Okay.
Ms. Rivera, if you want, the judge will sign an order allowing you to go into the substance abuse program in the Broward County Jail if you're interested in that.
Is that something you want to participate in, ma'am?
I don't know the details of it.
Sure. What?
Like how long it is or anything like that.
It's basically
nothing that would prevent you from being released from jail if the no bond hold is resolved and you're able to post bond. I mean, you wouldn't be detained in there unless it was through a court order that you finished the program. But to get into the program, which is kind of like an NAAA type program, they have meetings, and you're in an environment with other people who are trying to deal with their addiction issues.
Sir, I'm so sorry, but can you repeat the beginning of that? I would not be being held on the no bond anymore?
Well, if you were able to resolve the no bond hold and resolve your other cases, say they offer you probation or something like that on everything, just because you're in the SAP program, that wouldn't keep you in the jail, unless the judge ordered that as a condition of probation. So it's nothing that would prevent you from getting out of jail down the road.
Oh, okay.
But if you're interested in being involved in that type of environment where they have the meetings and they have these other things going on, the judge would be willing to sign an order allowing you access into that program, if you're interested.
I'll be frank with you. I'm a doctor. I treat sex offenders normally as we speak. My groups are being covered. I need this to be remedied as quickly as possible, but my health is at stake. My license is at stake.
I understand.
If the SAP program is something that is a viable option for me, do it.
It's not so much an option as to how you are going to spend your time waiting to go to court. It's not going to result in anything being dismissed. It might look more favorable for you when you do go to court. There's nothing that Judge Singal today can do about the no bond hold that's on you.
Can he do anything about the other $3,000 bond that's holding me, even if the no bond goes away?
He can.
I would like to ask for a reduction in that if possible.
Let me see if you have a court date.
Thank you, sir.
No, I don't see one. The only one I see is for today. And let me look at the 2017 case. You have a court date of September 21st.
Oh my goodness.
That's the case she was revoked on?
I'm sorry?
That's the Kara Fedmo?
Yeah.
She was in front of the judge you saw today, this morning.
What's that?
She was in front of the judge you saw this morning.
Yeah.
Yes, that's the one that he revoked the bond on.
That's what I'm saying. I'm not surprised that the next hearing's out in September.
Right. The only other thing I can tell you is, do you have Stephanie Alliston as your attorney?
Stephanie Allison?
Yeah. Looks
Yes,
like
sir.
she's your public defender, right?
Yes, sir. I'm thinking about obtaining private counsel, I'll be honest with you.
Okay, that's fine. I would hope you would be honest with us. You know, you just let us know if you do that so we can forward all the paperwork to your attorney. But right now, I guess the question is, do you want to go into the SAP program and get some help for your drug addiction while you're in jail?
Yes, sir.
Okay.
All right, so what we'll do is I'll go ahead and sign an order if you think it needs to be on both cases, ordering Dr. Rivera into the SAP program. And ma'am, I do wish you the best of luck.
Thank you for addressing me with my title.
Okay, thank you, ma'am.
Thank you.
Okay, next one is, here, let's see, hold on one second.
This is Amy Tedder.
Amy Tedder, is that you? All right.
Yes,
Okay.
sir. Hi.
Last but not least.
Right.
Sorry about that.
Okay.
Okay, and this is on page 3 of our second look docket. Looks like Ms. Tedder has been in custody since the 6th of June.
This is a motion to release, Judge.
Sure.
And the state has now filed an information
Okay.
at this time, so Ms. Tedder
All
is
right, so Ms.
entitled to
Tedder, I'm going to sign an order releasing you.
Okay,
Now,
thank you.
now listen to me, because a lot of people get confused about this. I'm not signing an order dismissing your case. I'm releasing you. What that means is if the state were to file charges on these matters, then something will be sent to whatever that last known address is that you have, and then you still need to come to court. Okay?
Now, and if there's a phone number I can call also too while
Absolutely.
I'm
Clerk's
going
office.
back into drug treatment.
Okay, all right.
And I finished SAP on, I'm sorry, Your Honor. I also finished SAP Friday. Does that matter, the completion? Because I technically volunteered but was ordered into it.
I would suggest that that certificate that you get, that you just hold on to it, so just in case this charge gets filed, you can show the judge the steps that you took, and I think that will really help you resolve the case. Hopefully you're in a situation where it doesn't get filed, but what happens is, just like Mr. Reedy had mentioned earlier, these kind of charges, although this isn't a drug charge per se, sometimes these charges take a little longer to file, but hopefully you're good to go.
Okay. Thank you, Your Honor.
I wish you the
bring that
best of luck.
certificate to court with you.
Yes.
Yes.
I won't receive that certificate till tomorrow. When will I be relieved?
No, you should actually, look, they're not gonna hold your release for you to get that certificate.
Right. No, I know.
Yeah.
Okay, so I'll be released today?
It should be today. Yes.
Okay.
Okay?
All right.
All right.
Thank you.
Thank you. Good? All right. You have one left? Which one do you have?
Yes, he did.
Yes. Anyone else think that we?
I think we covered everyone.
You've got it? Mr. Reedy, you've got everything? You guys have everything taken care of? Okay. All right.
I have another question. Mr. Dan